Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. This is a big deal. This U.S. Supreme Court is hearing another case for veterans. The results of this could impact how the VA decides who gets service connected and who is not. This is a big, big deal. There are two veterans that are pushing this issue at the Supreme Court level. And from my understanding, they are actually hearing arguments today, Wednesday, October 16th. So I wanted to share this information with you, kind of outline it, read an article here. I did a other video on this earlier, and I'm just pushing this one out to kind of do a double whammy for you. So please hit the thumbs up, subscribe, share with a friend, all that good stuff. I really appreciate it. Every thumbs up and every minute watched helps to push this into the hands of those that need it. If you want to support the channel in other ways, consider being a member. You can do that by going to the homepage. You'll see highlighted members and a join button. Thank you so much to all you members. I truly appreciate you. All right, so the headline here is Supreme Court to weigh veteran disability denials affecting untold number of vets. Okay, so you file your claim, you appeal it within the, well, you get a higher level review or supplemental claim, you have the VA review it, you don't like it, you push it to the Board of Veterans Appeals, or you push it to the next level and you go from there. Well, this is going to change how they may review that and could overturn decisions potentially more favorably for veterans. All right, so let's do this little subtitle. The case could have profound implications for untold number of veterans, challengers said. Now, this is found on usatoday.com and came out today, October 16th, 2024, by Maureen Grope. All right, let's see here. I am going to go through it and we'll go from there. Norman Thornton, a veteran of the First Gulf War, thinks the government owes him bigger disability payments for his PTSD. Joshua Buffkin was denied post-traumatic stress disorder benefits after leaving the Air Force because doctors didn't agree whether he qualified. Both sought a review of their claims from a special veterans court, which sided against them. So essentially what they're saying there is the veterans filed a claim. Then they probably filed either a higher level review or a supplemental claim. Then that was probably, well, it was denied, and they filed a claim with the Board of Veterans Appeals. That court then did not rule in their favor and denied them again. Then they pushed it to the U.S. Court of Appeals for Veterans Claims, which is the next level court, of which they also denied them. Now it ends up with the Supreme Court, which is where we are at now. So now the Supreme Court is considering how the U.S. Court of Appeals for Veterans Claims should review benefit denials and how to ensure decisions are tipped in a veteran's favor when they are a close call. So what is supposed to happen is if evidence is in equipoise, remember, I mean, there's information coming in from both sides, things that are ruling in your favor, things that are ruling against you, and at the end of the day, there's two stacks. If those two stacks are pretty close, evidence is in equipoise, equal on both sides, the VA is supposed to rule in your favor. Doesn't always happen, I get it. But the courts are supposed to fix that. In this case, these two veterans are feeling as though that did not get fixed, and apparently there's enough information there for, one, attorneys to back these veterans, and two, the Supreme Court to actually take this case on and start to hear these oral arguments. So let's move on. This issue, the justices are taking up Wednesday, could be and could have profound implications for untold number of veterans. Lawyers for Thornton and Buffkin said in a legal filing about the disability determinations made by the U.S. Department of Veterans Affairs. VA often errors in benefit adjudications. True. And the difference between an award and a denial has life-altering consequences for disabled veterans, the lawyers wrote. Again, true. The challengers have been or have the backing of several veterans groups who argued that veterans have been entitled to the benefit of the doubt for service-connected disability payments for more than a century. And Congress has twice stepped in to ensure that happens. So it's the benefit of the doubt, right? Ensuring that the veteran gets the benefit of the doubt. In 1988, Congress created the Veterans Court to review disputed determinations and codify the requirement that scales should be tipped in favor of the veteran in close cases. So that's a very important piece. Again, it's the benefit of the doubt aspect. But veterans groups complained that the new court was being too differential to the VA when reviewing the agency's decisions. In 2002, Congress directed the Veterans Court to take due account of the VA's application of the benefit of the doubt requirement. The difficulty comes when the two sides disagree over whether a denied disability claim was near the threshold for approval, and the law calls for a ruling in the veteran's favor. The federal government says the Veterans Court must only review the decision for a clear error, not reevaluate each piece of evidence. The veterans say Congress wanted a more thorough review, especially because the evidence is often not clear-cut. So, in Buffkin's case, the Veterans Court found nothing obviously wrong with the VA's determination that one doctor's assessment about whether he suffered from service-related PTSD was more comprehensive and persuasive than another's. His lawyers argue the court failed to review whether the VA applied the benefit of the doubt standard to the full set of evidence. Buffkin said he was traumatized by being caught between his wife's threats to kill herself if he didn't leave the military, and the military's alleged response that he could leave this service or get a divorce. He could leave this? Oh, okay. Got it. The federal government said Buffkin's case was not a close call as the preponderance of evidence was against him. Similarly, it's hard for me to say that word, in a similar situation, in Thornton's case, the VA found the cumulative evidence showed Thornton did not merit a higher level of disability payment. He put in for an increase. Thornton has had difficulty with work and with social interactions, among other issues, qualifying him as 50% disabled. It doesn't say it here, but on the mental health schedule, according to the VA. But Thornton said his disability rating should be higher based on one examiner's assessment of how he has dissociative episodes, I'm not sure exactly that word, have affected his employment. So what they're talking about here is the employment piece, and with regard to the 100% rating, you need to have total occupational and social impairments, right? So they're probably talking about that with regard to the employment aspect, and then potentially getting to a 70% is what I am thinking. And this goes back to, and look, I don't know these people. I don't know what sort of evidence that they put to the VA. In my opinion, sure, there is the benefit of the doubt rule. They're supposed to rule in your favor. Do they always get it right? No. Does the courts, do they always get it right? Obviously, no. My thought is you need to do the best you can to supply a boatload of evidence in your favor to where it's not equal, right? It's more on your side. Utilize, when it comes to any sort of increase or really getting the appropriate rating for anything, use the words from the schedule of ratings. That's what they're rating you against. If you know what they're looking for, then you can have that conversation with your doctor and supply that as evidence to make it very easy for the VA to rule in your favor at the right level of compensation. Moving on. The U.S. Court of Appeals for the Federal Circuit agreed with the government that the Veterans Court properly reviewed both determinations. A decision in Buffkin versus McDonough is expected by summer. So, with that, I'd love to hear your thoughts. If you've run into the situation of, look, I supplied everything, evidence might have been close, I feel as though they should have ruled in my favor. If that's you, well, if you got denied and this goes through, you might have a nice foothold to get that claim approved. So with that, thanks so much for watching. I appreciate you. Have a great one. And remember, if we don't take care of each other, something went wrong.